I'm Bob Wisniewski. I am a workers' compensation lawyer. In fact, I am certified by the State Bar of Arizona as a specialist. Only 1% of the lawyers in Arizona are certified in their specialty area. We're going to talk today about what is an independent medical examination, or what's called an IME. It's part of the discovery process. Other times you've looked at some of our videos that talk about depositions and our mission statement and perhaps the stages of workers' compensation. And this is one of the parts of one of the stages, and where the insurance company, not all the time, but many times, will ask you for what they'll call an independent medical examination. Sometimes they do it to verify your doctor's treatment. Sometimes it's to determine causation of a particular condition to the event and the mechanism of the injury. Or sometimes it's to try to bring the claim to some conclusion as to whether or not you, as an injured worker, has a permanent disability or the extent of the permanent disability, or maybe even to look at to see if your doctor's evaluation of permanent disability is accurate. Unfortunately, many of these exams are not really independent, but some are really good and some aren't, but they're mostly favorable to the workers' compensation carrier. You must attend. It's a compulsory exam, and you must be on time. That is really a critical feature. You need to go to the examination and be there on time. Otherwise, they're going to ask the court to assess suspension benefits on you. They'll suspend your rights for not going, and the doctor gets a no-show fee, and they're very, very pricey. The minimum ones are in the $700 or $800 range, up to $1,500 to $2,000, and I've seen them in the mid-2000s. So you have to take these seriously. They have to give us a couple of weeks' notice. We will send the notice to you. Always read your mail, which is sometimes a difficult problem, or read your email. Make sure that if you cannot go for a particular reason, maybe you're having medical care that day or a family problem, let us know right away, and we can attempt to get the examination date and time rescheduled. But if you don't tell us right away, you must go to the exam. Now, there are times when there are emergencies. You're on the way to the exam and you blow out your tire. Please call us immediately. Let us know that. And, go there as soon as you can. Maybe even call the doctor's office and say, look, I've just had this blown tire. He may be able to move you ahead or behind somebody else that day. But if you don't attend and don't have a very good reason, and it looks like you're willfully not going there, they will suspend your benefits. And they'll also assess you with a fine. That's why it's very careful. We're very careful that you must read your mail, look at it, look at the dates. You've got to have some proof that you had an emergency. If the tire blows out, make sure you have the receipt where you had to have it fixed. If your failure to attend was not a willful failure, then we can argue that you would not be responsible for a suspension or for the independent medical examination costs. But for example, if you have a breakdown or a tire problem and you get it fixed, keep a copy of the receipt so that we can use that as proof that you weren't willfully missing the exam. But they're very serious. Now let's talk about when you get to the exam. The doctor is not your friend. He essentially is working for the insurance company. Don't exaggerate. Be careful with a pain diagram that he asks you to fill out. Everybody thinks that, well, the more I put on that form, then he's really going to believe me. It works the opposite. The more you put down, the more you exaggerate, it shows that you're not really a credible witness. So just be careful, don't exaggerate. Sometimes during the examination, the doctor's going to press down on your head if you have a back injury and ask you to express whether or not you have pain. You cannot have pain in your spine if he just simply presses down on your head. That's a trick, and they're trying to show that you're not a credible witness. Sometimes they'll drop a piece of paper on the floor and you pick it up, and they'll say, oh, they were able to reach down without a problem. For example, if you say to the doctor or in the form or during the conversation, I can't sit more than 5 minutes before I have to get up and move around, and you're in the exam now for 20 minutes. that means that you're not too credible if after 20 minutes you're still not able to, you're still sitting down. And he's saying, well, he told me in the early exam he could only sit for 5 minutes, but he sat for 20 minutes while I had him in the examination room. Accurately express where the problem or the pain or the restriction is. Don't talk. This is not a chance to sell your case to the independent examiner. The more you say, the more he'll use against you, but be very specific. If you are not able to point out specifically where it bothers you and you're very, very general, he's going to say that you have a global problem and you're not able to accurately express where the injury is. If you had prior injuries, tell him about it. Yeah, the new accident can aggravate that. If you have been to former chiropractors or what have you in the past, make sure you're accurate because they'll find the records. And if you don't express the truth, which is important, they're going to say, well, you told me you never had a back problem before and there's surgical scars on your back, or we found chiropractic records. You just tell the truth. Yeah, I went to a chiropractor a couple of years ago. I had an injury and I'm fine, and I've been fine for the last 2 years. That's why I haven't been to the chiropractor or a doctor in the last 2 years. If you're working, it's okay to tell them that. You don't be afraid. You just say, look, I'm going to feed my family, and it's painful, but I press on and go through it. Be careful where you describe like nerve damage. Don't use medical words. Just say, gee, it kind of is tingling down my leg or the back of my leg, or it's numb. Don't use medical terms. Don't try to be a doctor. Sometimes my clients hear a word and say, gee, my injury is at my C6, C7 level, and they point to their neck. They only know that because someone told them that in a medical record. You didn't know that before you were hurt. So just simply say, gee, it hurts at my neck right about where the collar of my shirt touches my hairline. Don't say C6, C7. That means you're really kind of getting off on your injury. Just be a regular person like you're telling your neighbor where it hurts. As you interchange and work with the doctor, some of them are pleasant, some of them are not pleasant. Don't be aggressive. Don't be disrespectful. If you had a treatment and you then stop treatment for a while, tell them that. They're going to know that from the medical records. Say, gee, I didn't go for care because I got hurt and then they denied my case and I had to litigate it to put it back on the books. And during that period of time, I couldn't get medical care. That doesn't mean I didn't have the problem. I just simply didn't have the funds or insurance to be able to go see a doctor. You can tape record the examination if you tell us that in advance and we advise the insurance company in advance. Some physicians that do independent examinations, if they're told that the claimant or the injured worker wants to tape record it, they will not do the examination, or they'll want their own tape recording. But you can't go in and spring it on them the day of or the day before, or you can't stick it in your shirt and try to tape record them on your phone. Don't minimize the problem and don't exaggerate the problem. Be specific. If it hurts all the time, tell him. If he tries to make you say it hurts on a scale of 1 to 10, that it's always a 10, don't fall for that if it's not always a 10. 10 is the worst pain you'll ever have. What they'll often say to you is, well, your injury was a year ago. What was it then? Oh, it was a 10. It's a year later and you've had some treatment. What is it now? Oh, it's still a 10. Then they're going to say, see, he's not able to get better. He's just exaggerating it. Sometimes you'll see the physician's assistant come in and take the history rather than the specific doctor that's doing the examination. Let us know about that. I suggest to folks that when they go into the examining room, they look at their watch or their phone and they record the time that they're in there and the time that the doctor who's doing the exam walks in. And then when he walks out, you record it and say, he was only in with me for 4 minutes or 5 minutes or what have you. Keep a note of that and then let us know after the examination. Don't discuss with the doctor anything your lawyer has told you. That's breaching what we call the attorney-client privilege. He may ask you about that. Some of the doctors are a little bit more aggressive in asking questions than others. don't tell them what we've said. You do not have to do anything in the examination that will be harmful to you. If they want some invasive testing, you can say, I don't really want, I'm going to pass on that now. They may send you for x-rays, MRIs, things of that nature. Typically, the doctor is not going to have a big conversation with you. Most times they're not going to give you their opinion. They're going to tell you, talk to your lawyer. It takes about 2 or 3 weeks after the examination to get the report. So we'll get it, and then we'll give it to you. And we always like you to bring it to your doctor and discuss it with your physician. In fact, one of the suggestions that I have is, say you're going to see their doctor on a Monday, try to make an appointment with your doctor that same day or the next day so that you have your own independent evaluation of your condition and your particular problems from your own doctor, and you can refute the doctor's findings by saying, gee, the next day I was in with the same doctor and he found problems. Be honest, because it's a credibility issue. You may get some paperwork at the beginning to fill out about your medical history. We'll get it and give it to you. Keep copies of anything. Don't just fill it out and bring it to their doctor without giving us a copy or keeping a copy. And then when the examination is over and we get the report, we will discuss it with you. And there are some things that are important, and there are some things that aren't important. If the doctor says that you're tall and you're not really that tall, that's not a real critical issue. So you will go through and try to question the examination report, but there's some things in the report that are not really that important. You may weigh 250 pounds and the doctor says you're 230. That's not going to make a big difference. But, if the doctor says, well, you're a female and it's a male, that's going to make a big difference. But you will get a chance to go through it and make some notes. But again, we're not here to be so aggressive with the doctor. The lawyers know how to cross-examine the doctors. They know whether they're going to get anything out of the doctor. Some doctors will give us certain testimony that's helpful to your case, and we're the ones that will bring that out. But we're looking for your input. So tell us how long you're in with them, how long, if he even touched your body or let you bend over and things of that nature. You cannot bring a family member to the exam. You cannot bring a friend to sit in the exam. You can bring a doctor. The law says you can bring a physician, but how many physicians are going to sit in a half-hour examination across town without you paying them an unusual amount of money for them to sit in? So the exam process is part of the discovery. You have to go. You'll ask us, why do I have to go? And, well, you have to go. Unfortunately, it's the way of the world. If you have questions after your exam, call me or Mr. Grajeda, and we'll give you the best advice we can.